Les organisateurs de cette journée, professeur Kella et Alperin, de m'avoir invité, moi qui ne suis même pas constitutionnaliste, donc il n'est pas vraiment de légitimité à être là, mais ça m'a permis déjà dans la matinée d'écouter deux exposés tout à fait intéressants, tout à fait riches et qui ouvrent des problèmes d'intérêt général, pas simplement pour la démocratie israélienne, mais véritablement pour la théorie du droit constitutionnel. Donc nous avons maintenant une deuxième session qui, j'ai l'impression, sera peut-être un peu plus théorique que la première, qui exposait la pratique constitutionnelle. Et je vais donner tout de suite la parole au professeur David Kretzmer, qui va nous parler de l'approche critique du processus constitutionnel ou de la révolution constitutionnelle en Israël. Professeur, please.
Merci beaucoup. I want to start off by saying that I'm embarrassed to speak to you for three reasons. The first reason is that I'm going to speak in English, and I would much prefer it if I can speak to you in French. But the second reason is that Justice Barak has just addressed you, and it's not easy for me to be somebody who follows Justice Barak in speaking. But the third reason is somewhat, I would say, more serious. And that my mandate today is to present the criticism of the so-called constitutional revolution. But the truth is, as Justice Barak mentioned in his talk, after the Basic Law was published in 1992, I wrote a small article in which I spoke about the mini-constitutional revolution which had taken place. And after the Mizrahi judgment, I wrote another article in which I expressed support for the approach taken by Justice Barak in the decision. But nevertheless, I think that I'm capable of presenting the criticism of the approach that we've heard from Justice Barak, not necessarily because I support all the criticisms, but I think that it is important to present them, and that is what I'm going to do, and that is my mandate here this morning. So I want to speak about four issues that arise. The first is the constitutional background. The second are the events of 1992 and the interpretation of those events. The third question, I will speak to a question which has been addressed, so I'll be very brief as what revolution are we talking about, and then I will of course get to the main point, and that is the criticism, and there I will deal with three issues. The first issue is the issue of legitimacy. The second issue is the issue of legality. And the third issue is the essential issue when you're dealing with constitutional questions, and that is the issue of politics, and that becomes an important issue in judging revolutions. So now let's start with the background, and this has been mentioned before, but of course when one talks about historical background, it very much depends how it's presented and how it's interpreted. And I'm not going to start with Israel's Declaration of Independence, but I'm going to start with the United Nations Partition Resolution, which was passed on the 29th of November 1947. And that, this Resolution 181, says the following. As you know, that resolution recommended that two states be established in what was formerly mandatory Palestine, a Jewish state and an Arab state. And the resolution says as follows: the provisional government of each of the new states was to make a declaration to the United Nations before independence that contains stipulations inter alia on protection of the holy places and freedom of religion and conscience, and prohibiting discrimination of any kind based on race, religion, language, or sex. The same resolution said specifically that each of the states that were to be established were to have an elected constitutional assembly that would establish a constitution for the state that would have certain protections, especially the protections mentioned here and the protections of minorities. So when we look at the Declaration of Independence, we see that they're talking about a constituent assembly, and we also see mentioned exactly the protection of the holy places and freedom of religion and conscience and prohibiting discrimination of any kind. We know historically what the source was. The Declaration of Independence was not relying on the 1947 partition resolution, but it did mention it as one of the grounds for the legitimization of creating Israel as a Jewish state, and it was looking for international legitimization. Now, this becomes important because while the notion of a constituent assembly which was going to be drawing up a constitution was specifically mentioned in the Declaration of Independence, it did not in fact reflect a real political commitment of the main forces in what was the Jewish community of the time to the adoption of a formal constitution. As those who read the Declaration of Independence see quite clearly, it says there that a constituent assembly will be elected no later than October 1948, and that the provisional branches of government would continue to operate until such time as the Constitution has been decided, and then the new branches of government will be elected according to the Constitution decided by the Constitutional Assembly. So clearly the notion was that you're establishing a body whose main task, or its only task, was to make this Constitution. It would not be fulfilling any other task, and then the country would operate under the rules and principles of this Constitution. The real revolution that happened in the constitutional history of Israel, the first revolution, was a law which was unnoticed, in a way, passed by the Provisional Council of Government at the time, which the Provisional Council of State at the time, which was the temporary legislator, in which it said that when the Constituent Assembly has been elected, the Provisional Council of State will be dissolved and all its powers will be transferred to the Constituent Assembly. So this Constituent Assembly is now elected, and it does, in fact, have two heads. It's been elected as a Constituent Assembly according to the Partition Resolution, but more specifically according to the Declaration of Independence and according to the Special Elections Law that was passed. But it now possesses the powers of the legislative body. And it, immediately, its first act was to call itself the First Knesset and kind of try to push aside the whole notion of a constituent assembly. Now, as you know, and you've been told, that constituent assembly did not fulfill the task which was first and foremost elected to do. It did not make a constitution for Israel. It did not pass any basic laws. And it's interesting and it's very important to understand the reasons why. There were deep divisions in Israeli society at the time on questions of substance and questions of form. Questions of substance, there were wide divisions between socialist, some Marxist socialist and liberal views. There were very, very great tensions between the religious, non-religious, and sometimes ideologically secular and in certain ways anti-religious political forces in Israeli society. And there was certainly a notion that was accepted by labor parties at the time, and the Labor Party in Israel was the main hegemonic force, that we do not want judicial review. The Labor Party in Israel was not the only party to object to judicial review. The Labor Party in England had taken for a long time exactly the same approach. Why? We want to maintain power in the hands of the majority, which we hopefully will maintain in Parliament, and we don't want any elites, judicial elites, or any others to have any control, ultimate control over this. So this must be remembered. It must be remembered because this is not only a historical fact, That debate has continued in Israeli society, not necessarily the same divisions of substance. The socialist Marxist views are now no longer prevalent in Israeli society, but you still have the divisions between religious and non-religious. You have the views between very nationalistic and more liberal elements in Israeli society, and you have a division, as I will see, a very, very great division on whether Israel should be a country which has judicial review of legislation or not. So what happened? Well, a compromise was reached. And I want to read out the terms of that compromise because it's going to become quite important what I say later. And it says, the first Knesset assigns to the Constitution, Law and Justice Committee the preparation of a proposed constitution for the state. Note the proposed constitution for the state. The constitution will be made up of chapters, each of which will constitute a separate basic law. The chapters will be brought to the Knesset as the committee completes its work, and all the chapters together will constitute the constitution of the state. I'm going to come back to this a bit later when I talk about the question of legality. The first Knesset itself did not enact any basic laws. After it passed the Harari resolution, it pushed aside the whole notion of being a constituent assembly and then acted as a legislative body in a parliamentary democracy. It was not until 8 years after the Harari resolution was passed that the first basic law, the Knesset, was passed. And as we've heard, for many years, other basic laws were passed, all dealing with the institutions and branches of government, and some dealing with two questions, Israel lands and Jerusalem. But there was never consensus on two major issues, and basic laws could not be passed on those two issues. The one question was a Bill of Rights, and the other question was a question of the place of judiciary, and especially whether there should be judicial review, and if there should be judicial review, in whose hands? Only in the Supreme Court, or possibly in the hands of all courts. Now, this was not for lack of trying. Many attempts were made to enact such basic laws during the 70s, the 80s, and the 90s, but they were all frustrated during the parliamentary process. In 1990, 2 years before the basic laws which stand at the center of our discussion today were passed, the Minister of Justice at the time, Dan Meridor, presented a draft basic law on human rights. And yet one of the religious parties, which was in the coalition government of Israel, threatened to leave the government if this basic law was put forward to the Knesset. The minister had to back down. Actually, from many points of view, there was a positive development. Having lost on the ground of the basic law, the minister then decided to bring to the cabinet the notion that Israel should ratify the main human rights conventions, including the two international covenants on civil and political rights and on economic, social, and cultural rights. And the religious parties, for some reason, didn't object to that. They thought international law, what do we care? And the government ratified those, and so that was a direct result of the failure of the Minister of Justice to be able to get through the basic law, and he was committed to try and entrench or strengthen human rights. So what is the conclusion for that? And the conclusion, which is critical for our discussion, is that in the years since 1948, one could say, there has been no political consensus in Israel over a formal constitution. Two large movements were even created in Israel. One, the movement for a constitution. A lot of effort, a lot of money was expended trying to advance the cause of a constitution in the 80s, in the 90s, and in the present century, and they all failed. They failed because of lack of consensus and the notion that in order to adopt a constitution, we do have to have quite a large consensus. So now what happened in 1992? Well, in 1992 there was what may be termed a window of opportunity in the Knesset. At the time, there was a breakdown of the coalition in the period before elections. And for liberal members of the Knesset from various political parties, from the center to the moderate left, but even on the right, they were committed to the idea of having a basic law on human rights, and they thought that they would have the opportunity of getting such a law now through the parliament, through the Knesset. But in order to do so, they would have to make compromises. And they had to make compromises on certain levels. The first compromise was which rights are going to be included in the basic law. And the main objection up to then of the religious parties had been the objection to the notion of equality, because in the religious courts there's no equality between men and women, and they have control of matters of marriage and divorce, and that no mention should be made of freedom of religion or even of freedom of speech. In fact, in the original bill there was freedom of movement, and one of these religious parties said, no, we won't agree, because that may mean that you can allow traffic to go through our neighborhoods on the Sabbath. And so they said, okay, you want it, we'll take out freedom of movement. So you don't have a general clause on freedom of movement, you only have the clause on the right of any person to leave the country and the right of a citizen to enter the country. But once you're in the country, the law itself does not mention freedom of movement. They made another compromise. During the parliamentary process, the law originally said that it would be entrenched, that it could not be passed without a majority of 61. Well, two laws were passed. The one law dealing with the freedom of vocation, and that is entrenched. It cannot be changed except by a majority of 61. But the second and main law dealing with human dignity and liberty, the entrenchment clause was removed, and so it was passed without any entrenchment clause. However, and this was the main point of Justice Barak, and I'll admit that this was what stirred me at the time also to say, in the time that I personally still believe that this was a revolution by the Knesset and not by the court, was the limitations clause, in which it says that no one of the protected rights may be violated except by a law or under a law which is compatible with the values of the State of Israel, which is passed for a proper purpose, and which meets the proportionality requirement. It also had, as we mentioned, and that came up in the discussion with Justice Barak, that a clause that all existing legislation will remain, not only legislation, all existing laws, because that includes the religious laws which are not necessarily part of the legislation, will not be affected by the law. But I accept the argument that you could say, well, that was just making sure that you weren't going to say that stereo that they were vocating. Now, the important part is that these bills, which are so-called part of a revolution, were passed without any public debate, without any fanfare in the Knesset or outside the Knesset. The press hardly reported the passage of the laws at the time. They were not regarded as a significant event. Now, there may have been a few members of the parliament who knew that perhaps we're opening the way for a possibility of judicial review. But if the Knesset was carrying out a constitutional revolution at the time, it seems to me still that neither the members of parliament, the press, the public, or the academia were aware that this was what was happening. It would, what would maybe call a subconscious revolution. So now let's get down to the third point, and that is, well, what is this constitutional revolution? And I think that one has to distinguish between three features. Because in the Mizrahi case, the court only related to the one basic law, and Justice Barak mentioned this in his talk. They only said that the basic law on human dignity has constitutional status, and that legislation violating human rights which does not meet the requirements of the limitation clause would be invalid, and that the court would have the power to decide whether it met those limitations and to declare it valid. So there are two parts in that decision, one relating to the status of the basic law on human dignity and liberty, and second, to the idea that the courts had the power of judicial rule over legislation which ostensibly was incompatible with that basic law. But as Justice Barak mentioned, in later judgments, this was extended, expanded, so that the notion of the constitutional status was expanded to include all the basic laws. Under the theory, which I'll come to in a few minutes, that the Knesset, in passing the basic laws, was exercising its constituent powers, and therefore these laws were part of the Constitution. As such, they were inherently superior to ordinary legislation, and therefore when there was an argument that there's a clash between the basic laws and the legislation, it was emphatically the duty of the court to decide whether there was such a clash, and if so, whether the law was invalid. So the fundamental point about the Israeli constitutional resolution is in fact that it was the courts that decided that Israel had a formal constitution, that on the basis of that constitution there were limitations on the legislative power of Parliament, and that the courts could decide whether those limitations were respected or not. Now, the question of judicial review has been compared, of course, to Marbury versus Madison, but as pointed out in the previous session, of course, this is a limited parallel, because the United States Constitution specifically says that the Constitution should be the Supreme Court of the land, and all the court said in Marbury versus Madison, well, then it's obviously the province of the court to decide whether other laws are compatible with the Supreme Court of the land. But it was the court in Israel that decided that the basic laws were the Supreme Court of the land. If you accept that premise, then of course we can have the argument raised by Professor Tropper, well, does that necessarily mean judicial review? I don't think it necessarily means judicial review, although I entirely agree with Justice Barak that that was the preferred path to take, but I don't think it was the necessary path. The court could have taken a different path. I think it was right to take the path that it did, but it could have taken a different path. So the big question then, of course, is, does Israel have a formal constitution? And when I present this to people, it seems somewhat of a peculiar question. Well, surely a professor of constitutional law knows whether the country in which he teaches constitutional law has a constitution or not. But that is exactly the point there. Can there be a debate in a country over whether the very question of whether the country has a formal constitution or not? What does that imply? May the courts decide that a country has a constitution when there's an ongoing and lively debate on the very question of adoption on the constitution, and that debate rests on the notion that we do not have a constitution. And will this not ultimately be regarded as a political decision that courts should not be making? So now let me get to the criticisms. And as I said, I'm going to divide my criticisms into three major points. The first point is a question of legitimacy. The second point is a question of legality. And the third point is the question of the political implications of politics. So let's start with legitimacy. And the question then comes down to, well, how are constitutions made? And the making of a constitution is a purely political act. It's possibly the ultimate political act of a society. Quoting from a recent article which I read, while the Constitution lends legal legitimacy to all subsequent laws, institutions, and actors, the formation of the Constitution itself is necessarily an extra-constitutional or an unconstitutional process. The underlying logic behind this statement is that a constitution cannot effectively give birth to itself, given its role as the progenitor from which all legal legitimacy springs forth. So when do we have such a political act? Well, very often one has it at a historical moment. Clearly, when the State of Israel was established, there was a historical moment in which they could have had a constituent assembly, it could have adopted a constitution, and that constitution would clearly have had legitimacy, even though at the time there was only a small proportion of the population which afterwards flowed into the country from various parts of the globe. But when it's not adopted at some specific historical moment, such as independence, such as South Africa, a radical change from apartheid to a liberal democratic regime, well, one needs some special procedure based on wide consensus and a formative act of some sort by the society, a political act, a referendum, a constitutional assembly of some sort. In his work on constitutions, on adoption of constitutions, John Elster has written a great deal about this. The fact is that new constitutions are almost always written in the wake of a crisis or exceptional circumstances of some sort, and you are well aware of that when it comes to the constitution under which France is ruled to this very, very day. Now, political legitimacy is intimately connected both with the contents but with the process and nature of the body which adopts the constitution. And one has a problem in Israel, that you have a lack of consensus over the contents, and you certainly, therefore, especially have to pay attention, more attention possibly that would other be required to the process and nature of the body which adopts the Constitution. When you're living in a divided society in which there's such a large degree of disagreement over the contents, in order to give legitimacy to the formal Constitution, you have to be very, very convinced that the process and nature of the body which adopts the Constitution lends it the legitimacy required, even among those who are not really very happy with the contents of the Constitution. Now, my argument is, and this is fundamentally where I think I agree with Justice Barak in his argument with Justice Shamgar in the Mizrahi case, that the ordinary legislature does not have constituent power. It doesn't have the mandate from the people to draw up a constitution or to bind it for all times. It's also a body made up of politicians who have immediate political interests, who generally want a constitution to be drawn up with a bit of removal from the political fray of the time. It's not quite a thing that is supposed to reflect the personal interests of the people involved. As Rawls said, that should be a body made up of persons who do not know how the Constitution will affect their immediate interests. Of course, the question of legitimacy brings us back to Max Weber, who spoke about charismatic, traditional, or legal rational legitimacy. Well, we don't have the charismatic, we didn't have the traditional, what about the legal rational? Well, as a constitution is ultimately based on what I could call a self-enforcing bargain, rational authority is developed through creating and communicating a series of constitutional bargains, which even the relative losers would be better off living under it than not at all. So now let's see how the question of legitimacy has been reflected in the writings of those who have been the strongest opponents of the so-called constitutional revolution. Well, the most serious opposition came from one of the judges in the Mizrahi case, who later, it seems to me, came to terms with the revolution, but at the time, Justice Cheshin wrote a reasoned judgment taking his colleagues to task. And let me just read from what Justice Cheshin said. Like my colleagues, I too believe that we deserve a constitution and a constitution would befit us. But there are many, many eminent people who think otherwise, and in my view, their reasons warrant serious consideration, especially since the enactment of a constitution in certain respects means taking the path of no return. Indeed, even those supporting the adoption of a constitution should tread carefully lest they fall into traps, be wary of obstacles, lest they be plagued by pitfalls conspicuous and concealed. On the contrary, let the act be done and let a constitution be adopted, but it should be performed in a way of all nations. Let a constitution be drafted and submitted for a referendum. Let the constitution be adopted in a process of 6 readings spread over the 2 Knessets. Let any act be done, provided that it involves a substantial deviation from regular legislative proceedings, and provided that the people are involved in the enactment of the Constitution. Now, if we take this as a basis for legitimacy, clearly there was no substantial deviation from regular legislative proceedings. As has been mentioned, the laws of 1992, the Basic Law on Human Dignity and Liberty, was passed by less than 50% of the members of the Knesset. The Knesset made up 120. There were less than 60 members who actually participated in it. The main opponent, of course, of the very notion of a constitutional revolution, and this is somewhat paradoxical because he was the first judge to allow judicial review of parliamentary legislation, but Professor Klein spoke about that, was former Chief Justice Landau. And he had retired by the time the Mizrahi judgment was handed down, but he wrote a number of articles criticizing the court. And let me just read from what he said. President Shamgar stresses that in adoption of a constitution, there must be an element of festiveness, and nobody doubts this. But I wonder where the festiveness was when in the final vote on the Basic Law of 1992, less than half the members of the Knesset participated. An examination of the parliamentary record of that session reveals that not one of the participants in the debate was aware that they were at the moment engaged in a revolutionary and festive act of legislation which established a Bill of Rights as the Supreme Court of the land. The former chairperson of the Knesset Constitutional Law Committee, Michael Eitan, he presented the matter as follows. One day, or more precisely one night, in an atmosphere totally lacking festiveness, 2 laws were presented for the vote. Less than half the members of the House were present. Nobody mentioned that the Constituent Assembly was meeting. Nobody spoke about this being a revolution, and nobody said that they were making a constitutional change. A few months later, the people of Israel are told a revolution has taken place. Well, the first revolution that happened without the public knowing about it. Only after the event did it discover that there was a revolution. Those of the Knesset members who possibly knew that this was a far-fetching act intentionally hid that from the other members of Knesset. Is this the way a constitution is built? Now, I'm not going to go into the question of whether Eitania is correct in the way he describes the process, but this is a very deep perception. And this is from a person who was the chairperson of the Constitution Law Committee of the Knesset at a later stage. Now, when one deals with legitimacy, of course, the fundamental argument, and I think that's part of Justice Barak's argument as well, perhaps it didn't have that much legitimacy at the time. But the proof of the pudding is in the eating. And the ultimate judge of legitimacy of a constitution of any sort is whether it gains acceptance over time by the society. And while the act of the court in interpreting the basic laws as part of Israel's constitution may have been revolutionary and therefore in some sense extra constitutional, it has over the last 20 years gained legitimacy. The Knesset may not like it, but it accepts that the court has the power to review such legislation. In some cases, it reacts by passing legislation that will meet the demands of the court. We've just had a major case in Israel in which the Supreme Court unanimously, sitting in a bench of 9, ruled that a law passed by the Knesset for the detention of asylum seekers and other persons who entered Israel illegally, they could be held for detention for 3 years. That law was unconstitutional. The Knesset didn't say, so what, we're going to go on and act according to that law. They said, well, we'll now try to find another law which will meet the demands of the judges. So fundamentally one could say, well, it was a revolutionary act, but achieved what every revolution wants to do, and that is in the end to gain legitimacy. The courts certainly have internalized the idea of the basic law as constitutional law, but even the one justice on the Supreme Court, and I read from his justice who dissented in the Mizrahi case, later told the line and wrote a few judges in which he fundamentally accepted the superior status of the basic laws. The problem with this argument is that there are still large sections in Israeli society, represented in the Knesset by vocal and influential members of the main political party in the present coalition, as well as in the religious parties which are part of the coalition, or some of them are part of the coalition, who have acted strongly against what they see as the usurping by the Supreme Court of the role of the political branches of government. And as I will mention before, this has had serious political consequences, especially when it comes to the adoption of more basic laws. So that's on the question of legitimacy. But now let's get on to the question of legality. And everybody mentions the Constituent Assembly. And the theory first advanced by my friend and colleague Professor Klein was that, well, the Knesset has retained its constituent powers, and therefore the basic laws passed are part of the Constitution. But it seems to me that it's not as easy as all that, because two questions arise. It is true the first Knesset passed a law transferring all its powers to the next Knesset, and subsequently a law was passed transferring all these powers from each Knesset to the next. But the notion of the constituent powers was not mentioned, not expressly mentioned. So it's a matter of interpretation whether the Knesset really did intend to transfer not only its legislative powers and its powers of criticizing and voting no confidence in the government, but its constitutive powers. So that's a question of intent, but much more important than the question of intent is the question of authority. And here's a major legal question, and that is the question of whether a constituent assembly elected by the people to draw up a constitution has the power to transfer that power to some other body, even if it's a body which is elected only as a legislature. And this is not, in my mind, a trivial question, because if we accept ultimate political nature of drawing up a constitution and not the formal legalistic side of the issue, it would seem that the answer should be negative, that the Constitutional Assembly was elected to draw up a constitution. If it fails in this task, it returns the power to the people. And there will be another Constituent Assembly elected or some other way found to make the constitution. But what would have happened if the Constitutional Assembly had said, well, you know, we're very busy as a legislator, so we're going to give the power to draw up the constitution to the Municipal Council of Tel Aviv? Would that have been a lawful transfer of its powers? Would this have been valid? And Justice Feshet's main argument in this Mizrahi court, and I find it quite a persuasive argument, that a constituent body does not have the inherent power to transfer its power, its constitution-making powers, to any other body. So then one quotes the Harari resolution, which I cited. But the Harari resolution just begs the question, because it does say that the constitution will be made up of chapters, each of which will constitute a separate basic law, and that the chapters will be brought to the Knesset as the committee completes its work, and all the chapters together will constitute the constitution of the state. But it doesn't say by which process. is there not going to be some formal act at the end when all the chapters are completed and they are now part of the Constitution, that we will have some kind of festive act, possibly submitting it to a